Today, our focus is on winding up and dissolution of companies. Let's begin with the relevant laws. The key legislations governing this area are the Companies and Allied Matters Act of 2020, the Winding Up Rules of 2001, the Federal High Court Act and Civil Procedure Rules, and the Investments and Securities Act. We also have the Securities and Exchange Commission Consolidated Rules of 2013, the Banks and Other Financial Institutions Act, the Nigerian Communication Commission Act, and finally, the Companies Proceedings Rules of 1992. And remember, this list is not exhaustive. There are other supporting regulations that may come into play. Now, let's turn to the regulatory agencies. Two agencies are central here. First, the Corporate Affairs Commission, or CAC. The CAC can present a petition for winding up. It is also the custodian of company winding up process. It is also the custodian of company records. And even during the winding up process, companies are still required to file returns with the CAC. The second key body is the Federal High Court, which is the court with jurisdiction to entertain winding up petitions. Moving on, how can a company's corporate personality be terminated under CAMA? There are essentially two ways. 1, through winding up, and 2, by striking off the company's name from the register of companies if it has become defunct. This latter option is covered under Section 692 of CAMA. Now, let's unpack the meaning of winding up itself. Winding up is the process by which a company is liquidated and dissolved, with its assets distributed according to the rules of priority. This ensures that creditors, members, and even employees receive what the law entitles them to. Importantly, there can be no dissolution without first undergoing winding up. Dissolution comes at the very end, but winding up is what facilitates the distribution of assets. A famous case illustrates the gravity of this process. In Tate Industries plc against Defcom BM Limited, 2004, it was said that a winding up proceeding is the signing of the death warrant of a company or a pronouncement of the death of the company. It is a very serious matter. End quote. And indeed, that statement best captures how weighty winding up truly is. Now, there are different modes of winding up, which is particularly important for the bar part 2. Winding up may be done in one of 3 ways. First, compulsory winding up by the court. Second, voluntary winding up. And third, winding up subject to the supervision of the courts. Focusing on voluntary winding up for a moment, this itself can take 2 forms. It may be carried out by the members or by the creditors. And timing is important. If a company passes a resolution for voluntary winding up before any petition is presented, then the winding up is deemed to have commenced at the time the resolution passed. If a company passes a resolution for voluntary winding up before any petition is presented, then the winding up is deemed to have commenced at the time the resolution was passed. That is section 578 of Kama, subsection 1. But if there is no resolution, or if any other situation, then it is deemed to have commenced at the time the petition for winding up was actually presented. That is section 578, subsection 2. Let's talk now about contributories. Contributories are bound to contribute to the assets of the company once winding up has commenced. Who qualifies as a contributory? Two categories of people. First, present and past members. That is provided under sections 525 and 117 of Kama. And second, any person liable to contribute to the assets of the company, such as someone who had been a member at any time between the 12 months prior to the commencement of the winding up. That is covered by section 556. Now, let us focus on compulsory winding up by the courts. Under section 571 of Kama, the courts may order that a company be wound up, but only upon a petition being presented to it. The court cannot act on its own. It must be formally invited through a petition. So who is eligible to bring such a petition? This is a crucial bar part 2 focus area. 8 categories of people may petition. 1. The company itself or one of its directors. 2. A creditor, and this includes contingent or prospective creditors. 3. An official receiver. 4. A contributory. 5. A trustee in bankruptcy or the person representative of a creditor or contributory. 6. The company's affairs commission under sections 323 of the Companies and Allied Matters Act. 7. A receiver, but only if authorized by the instrument under which he or she was appointed. And finally, a petition may be brought by any or all of these parties acting together or separately. I'll repeat. 8 categories of people may petition. Number 1, the company itself or one of its directors. 2, a creditor, and this includes contingent or prospective creditors. 3, the official receiver. 4, a contributory. 5, a trustee in bankruptcy or the personal representative of a creditor or contributory. 6, the CAC under section 323 of Kama. 7, a receiver, but only if authorized by the instrument under which he or she was appointed. And finally, a petition may be brought by any or all of these parties acting together or separately. Now, let's examine the eligibility of certain persons more closely, starting with contributories. A contributory is not automatically entitled to present a petition for winding up. 2 conditions must be satisfied. First, the number of members must have been reduced to 2 in the case of companies that normally have more than one shareholder. And second, the contributory must have held shares allotted to him for at least 6 months during the 18 months before the commencement of the winding up proceedings. That's under section 573, subsection 2 of the Companies and Allied Matters Act. Next, contingent or prospective creditors. The law is careful here. The court will not entertain a winding up petition from such creditors unless two requirements are met. 1. They must provide sufficient security for costs, and they must establish a prima facie case for winding up to the satisfaction of the courts. That's section 573, subsection 2, paragraph C of the Companies and Allied Matters Act 2020. Now, which court has jurisdiction over winding up matters? The Federal High Court of Nigeria, but not just any division of the courts. It must be the division within the jurisdiction of the company's registered office or head office. Section 570, subsection 1 of the Companies and Allied Matters Act 2020 makes this clear. And for the purposes of this rule, registered office or head office is defined as the place which has been the principal place of business of the company for the longest period during the 6 months immediately preceding the presentation of the petition. This is under section 570, subsection 2 of the Companies and Allied Matters Act 2020. It is also important to note that once a company is in the process of winding up by the courts, any attachment, distress, execution, or sequestration against the company will be void. That safeguard is provided under section 776 of the Companies and Allied Matters Act 2020. To illustrate jurisdiction, let's look at a sample question. Suppose Tuna Limited was incorporated in 2010 with its registered office in Lagos. In December 2022, the company expanded to Abuja and moved most of its operations there. Unfortunately, the move was not profitable, and by October 2023, the members decide they want to petition for winding up. Which court would have jurisdiction? The answer is the Federal High Court of Abuja, because Abuja has been the principal place of business during the last 6 months of 2023. Now, let's look at the grounds for compulsory winding up by the courts. Another bar part 2 focus area. There are 6 major grounds. First, where the company has, by special resolution, agreed that it should be wound up by the courts. Second, where the company defaults in delivering its statutory reports to the Corporate Affairs Commission, or in holding its statutory meeting. Third, where the number of members falls below 2. Fourth, where the company is unable to pay its debts. Fifth, where a condition precedent to the operation of the company has ceased to exist. And sixth, where the court forms the opinion that it is just and equitable for the company to be wound up. I'll take it again. There are 6 major grounds for the winding up of a company compulsorily by the courts. And they are: first, where the company has by special resolution agreed that it should be wound up by the courts. Second, where the company defaults in delivering its statutory reports to the CAC or in holding its statutory meeting. Third, where the number of members falls below 2. Fourth, where the company is unable to pay its debts. Fifth, where a condition precedent to the operation of the company has ceased to exist. And sixth, where the court forms the opinion that it is just and equitable for the company to be wound up. Let's take these grounds one by one. The first is members' special resolution for compulsory winding up. Regulation 43 of the Companies Regulation 2012 sets out the steps for this. First, the board must pass a resolution for winding up. Then, a general meeting must be convened, and at that meeting, the company must pass a resolution, a special resolution for winding up by the court, pursuant to Section 571, Paragraph A of the Companies and Allied Matters Act. Next, the company must send notice of the special resolution to the Corporate Affairs Commission within 14 days of its passing, and also to the Nigerian Stock Exchange and the Securities and Exchange Commission if it is a quoted company. After this, a petition for winding up is presented to the court, accompanied by a verifying affidavit and a copy of the resolution. If satisfied, the court will make a winding up order and appoint a liquidator. Certified true copies of the court order must then be filed, and the liquidator must file notice of his appointment within 14 days. A notice of this appointment must be published in the official gazettes or in 2 daily newspapers. Furthermore, the liquidator must provide an account of receipts and payments at least twice a year, in duplicate and verified by statutory declaration. Finally, upon application, the court will order the dissolution of the company. At this point, the following must be filed: a certified true copy of the court order for dissolution, updated annual returns and other filings, the original certificate of incorporation or a certified true copy for cancellation and evidence of payment of fees. The second round is default in delivering the statutory reports or holding the statutory meeting. Only a shareholder of the company may bring a petition on this ground, and it must be brought within 14 days after the last day on which the meeting ought to have held. This is under Section 235 of the Companies and Allied Matters Act 2020. Note that this ground applies only to public companies, because only public companies are required to hold statutory meetings within 6 months and to deliver a statutory report within 14 days of sending copies to members, as stated in Section 235, subsections 1 and 6 of the Companies and Allied Matters Act 2020. Where a petition is brought on this ground, the court may decide, instead of ordering winding up, to simply order that the statutory meeting be held out of time, or that the reports be delivered. The court may also make whatever orders as to costs as it considers appropriate. The third ground is reduction of members below 2. As a general rule, a company cannot be incorporated with fewer than 2 members, except in the case of a private company. That is under Section 18 of the Companies and Allied Matters Act 2020. For private companies, the situation usually arises where all members are deceased and their personal representatives have taken no steps. If this requirement is not met, the company may be wound up by the courts in addition to any other sanctions. Notably, this is one of the circumstances where a contributory is expressly authorized to bring a petition for winding up, as stated in Section 573, subsection 2. Finally, the fourth ground we will cover here is inability to pay debts, which is dealt with under Section 572 of CAMA. This is what is referred to as a cash flow insolvency. Essentially, the inability of a company to meet its financial obligations as they fall due. A company will be deemed unable to pay its debts if a creditor, whether directly or by assignment, is owed a sum exceeding 200,000 naira, and that creditor has served on the company by leaving it at its registered office or head office a demand letter under his hand requiring payments. If for 3 weeks after the service the company neglects to pay or to secure or compound the debt to the creditor's reasonable satisfaction, then the company is deemed unable to pay its debts. Now, Section 19 of the Business Facilitation Act has amended Section 572 of the Companies and Allied Matters Act 2020. It now states that the amount involved shall be a sum to be determined by regulations issued by the Commission. This means that the exact threshold debt for inability to pay will be fixed by a regulation of the Corporate Affairs Commission. So, what are the conditions for winding up on inability to pay debts under Section 571, paragraph D of the Companies and Allied Matters Act? 4 essential ingredients must coexist. 1. There must be a debt in a sum determined by regulation of the Commission. 2. The debt must be due. 3. A formal notice of demand under the creditor's hand must have been served on the company. 4. And finally, the company must fail to pay within 3 weeks of service. There is an exception where the debt is contentious, meaning the amount owed is in general dispute. The court will refuse to grant a winding up order. We see this in Onoche against Alandic & Co. Limited, 2003, as well as State Industries PLC versus Defcom MB Limited, 2004. In such cases, the matter will instead be referred to the State High Court to determine the debt. Take note of the following. The debt must be a liquidated sum, one that exists and is admitted. If it is disputed, the court will not grant a winding up order. See Re against Bitney & Co. Nigeria Limited. And about the demand, it is not an ordinary letter, but a statutory document. It must be formally titled Statutory Demand for Payments. It must clearly set out the amount owed, include a request to pay within 3 weeks, and states that failure to do so will lead to winding up proceedings. This is in Section 572, paragraph A of the Companies and Allied Matters Act. Service of this demand is done by leaving it at the company's registered office. In Nigeria Commercial and Industry Enterprises Limited against Registrar of Companies, A petition was dismissed because it had been brought before the expiration of the required 3 weeks. Condition precedent to the operation of the company. The fifth ground arises where the condition precedent to the company's operation has ceased to exist. For example, if the sole object of the company has become illegal, a petition can be brought to wind it up. Just and equitable grounds. The sixth ground is winding up on just and equitable grounds, found in section 571, paragraph F of the Companies and Allied Matters Act 2020. Several circumstances fall under this head. 1. Where the substratum of the company has disappeared, such as when the company can no longer achieve its object clause or it is hopelessly indebted. See Yeni DJ Tobacco Limited. 2. Where the company was formed for fraudulent purposes. 3. Where the company is nothing more than a bubble, no real business, no assets. 4. Where there are unfairly prejudicial or discriminatory acts against minority members, as in Ibrahimi against Westbourne Galleries Limited. 5. If the company is a small going concern, then grounds that would ordinarily dissolve a partnership may also suffice. This is seen in the matter of Steve Doring Nigeria Limited Co. Limited. 6. If the company was incorporated for an illegal purpose. 7. Where there is misappropriation of funds. 8. Where there are repeated unfair acts against minorities. 9. And finally, where it is impossible for the company to achieve its objects, as in the Crown Bank case. Where the court is faced with a petition under this ground, certain factors guide its discretion. Whether it is just and equitable depends on the facts available to the court at the hearing. See Wonderflex Textiles Property Limited, 1951. Also note, a petition on just and equitable grounds will not be dismissed merely because the petitioner has other remedies. The motive of the petitioner is irrelevant. This is established in Obasi against Pureway Corporation Limited, 1878. However, the petitioner must not be pursuing purely selfish objectives. If the petition is simply a tactic in a personal quarrel with other shareholders, the court will not grant a winding up order. This is the position in Anglo-American Brush Corporation Limited against Scottish Brush Company Limited. Commencement of winding up by the courts. Under Section 578 of the Companies and Allied Matters Act 2020, the commencement of winding up is determined in this way. 1. If a member's special resolution to wind up was passed, then winding up is deemed to have commenced at that time. 2. In every other case, winding up commences at the time the petition was filed. See Mike Chantal Bank of Nigeria PLC against Onwa Abudi. Procedural steps in compulsory winding up. The process of compulsory winding up is detailed and involves 21 steps. 1. Filing the petition together with a verifying affidavit. 2. Serving the petition and filing proof of service. 3. Obtaining leave of court to advertise the petition. 4. advertising the petition. 5. Filing a memorandum of compliance by the petitioner. 6. The respondent may then file a notice of intention to appear along with affidavits in opposition and in reply. 7. Appointment of a provisional liquidator, filing and hearing summons for costs. 9. Filing the list of persons appearing as creditors. 10. Hearing of the petition. 11. The courts making a winding up order. 12. The winding up order is serviced. 13. Delivery of the company's statement of affairs. 14. The official receiver's preliminary reports. 15. The first meeting of creditors and contributories. 16. Appointment of a liquidator. 17. Advertisement of the liquidator's appointment. 18. Appointment of a committee of inspection. 19. Winding up conducted by the liquidator. 20. Application for a dissolution order. 21. Finally, the dissolution order itself. Some notable points. Under Section 617, subsection 1 of the Companies and Allied Matters Act 2020, in compulsory winding up, dissolution occurs at the time of the dissolution order or at any later date specified in the order. No dissolution of property of the company is allowed. Section 776 of the Companies and Allied Matters Act makes such dispositions void. Likewise, no attachments or execution against the company's executives. Likewise, no attachments or executions against the company's property are valid after the commencement of winding up under Section 577 of the Companies and Allied Matters Act 2020, except for holders of fixed charges or perfected security interests. 2. Proceedings may be stayed under a winding up order under Section 601 sub 1 of the Companies and Allied Matters Act, if justice so requires. This is not just an appeal, but a review of the proceedings leading to the order. Applications may be made by the liquidator, the official receiver, and the creditor or contributor. The effects of a winding up order are also significant. No actions can be brought against the company without leave of courts. Employees are laid off. The order operates in favor of all creditors and contributories, and the director's powers to manage the company cease. See Onwucheka against NDIC, Nigerian Deposit Insurance Commission. Powers of the court in compulsory winding up. The court has wide powers, including 1. To stay the winding up order, Section 601 of the Companies and Allied Matters Act. 2. To order set-off of contributories, see Section 604 of the Companies and Allied Matters Act. 3. To make calls, see Section 605 of the Companies and Allied Matters Act. 4. To order payments into a special account, see Section 606 of the Companies and Allied Matters Act. 5. To exclude a creditor who fails to prove in time, see Section 608 of the Companies and Allied Matters Act. 6. To order inspection of books. See Section 610 of the Companies and Allied Matters Act. 7. To direct that the cost of winding up be paid from company assets. See Section 611 of the Companies and Allied Matters Act. 8. To summon persons suspected of holding company property. See Section 612 of the Companies and Allied Matters Act. 9. To order the public examination of promoters and officials of the company. See Section 613 of the Companies and Allied Matters Act. Appointment of a liquidator. The court may appoint a liquidator to conduct the winding up proceedings. If no liquidator is appointed at the time the order is made, then the official receiver becomes the liquidator by virtue of his office. Powers of the liquidator. The liquidator's powers in winding up by courts require the sanction of either the court or the committee of inspection. These powers include: 1. Bringing or defending actions in the name of the company, as in Agbaoye against Chief Federal Land Officer. 2. Carrying on the company's business, but only as may be necessary for beneficial winding up. 3. Appointing professionals, including legal practitioners, to assist him. 4. Paying creditors in full. 5. Making compromises or arrangements with creditors. 6. Compromising on calls, debts, and liabilities capable of resulting in debts. Voluntary winding up. Now, let's shift to voluntary winding up. Here, members pass a resolution that the company should be wound up. The affairs of the winding up are conducted without recourse to the courts. There is no need to file a petition in courts. Under Section 620 of the Companies and Allied Matters Act, a company may be wound up voluntarily in 2 circumstances. First, when the period fixed for the duration of the company in its articles has expired, or when an event occurs that the articles provided should trigger dissolution, and the company in general meeting resolves accordingly. Second, in any other case where the company passes a special resolution to be wound up voluntarily. When a company passes a resolution of that nature, Section 621 of the Companies and Allied Matters Act requires that within 14 days, notice must be given by advertisement in the Gazette or in 2 daily newspapers, and notice must also be given to the Commission. Failure to do so attracts penalties. Under Section 622, voluntary winding up is deemed to commence at the time the resolution is passed. There are 2 types of winding up voluntarily. The first is members' voluntary winding up, and the second is creditors' voluntary winding up. The difference depends on whether or not a declaration of solvency is made. A member's voluntary winding up happens where a declaration of solvency has been made. A creditor's voluntary winding up happens where no such declaration has been made. Declaration of solvency. The declaration of solvency is a statutory declaration by the directors or by the majority if the company has more than 2 directors, stating that they have fully inquired into the affairs of the company and believe it will be able to pay its debts in full within 12 months of commencement. This is under Section 625 of the Companies and Allied Matters Act. The declaration must be made within 5 weeks before the passing of the resolution and delivered to the Commission for registration for that date. It must also include a statement of the company's assets and liabilities. If this is not done, the declaration has no effect. Note that all costs and expenses of winding up, including the liquidator's remuneration, are paid from the company's assets in priority to all other claims. Members' voluntary winding up. The procedure for members' voluntary winding up is important for Bar Part 2. The steps include 1. The board resolution that the company be wound up voluntarily. 2. A statutory declaration of solvency signed by a majority of directors with a statement of assets and liabilities filed at the CAC within 5 weeks. 3. Convening a general meeting. 4. Members passing a special resolution for voluntary winding up and for the appointment of a liquidator. This must be signed by either one director and the secretary or 2 directors and must be passed within 5 weeks of the declaration. 5. Filing the resolution and declaration with the CAC within 15 days. 6. Publishing the resolution in the Gazette and in 2 daily newspapers. 7. Resolution for appointment of a liquidator. 8. Publication of the liquidator's appointment within 14 days. 9. Filing the notice of appointment with the CAC within 14 days. 10. If the winding up takes more than 1 year, the liquidator must convene a general meeting and present accounts. 11. The liquidator convenes a final dissolution meeting, advertising it in the Gazette and in 2 newspapers. 12. At the meeting, the liquidator lays all accounts bare before the members. 13. The accounts and return of the final meeting must be filed with the Corporate Affairs Commission within 7 days. 14. The original certificate of registration or a certified true copy must be delivered to the Corporate Affairs Commission for cancellation under Sections 630 and 631 of the Companies and Allied Matters Act. 15. After 3 months of registration, the company is deemed dissolved unless the court orders otherwise. Thus, in voluntary winding up, a company is dissolved 3 months after the accounts and returns are filed with the Corporate Affairs Commission. Members' voluntary winding up may also convert to creditors' voluntary winding up if and only if no declaration of solvency was filed or if the liquidator forms the opinion that the company will not be able to pay its debts within 12 months. Creditors' voluntary winding up. Creditors' voluntary winding up under Sections 335 and 641 of the Companies and Allied Matters Act occurs where no declaration of solvency has been made. The procedure, another bar part 2 focus is as follows. 1. The company summons separate meetings of creditors and members. The creditors' meeting is held first. 2. Notice of the creditors' meeting must be published in the Gazette and in 2 newspapers. 3. The creditors' meeting is presided over by a director. 4. Directors must, at least 14 days before, send creditors a full statement of affairs, including assets, debts, and liabilities, along with a list of creditors. At the meetings, both the company and the creditors nominate a liquidator. The creditors may also appoint a committee of inspection of up to 5 persons. The members pass a resolution for winding up and notify the CAC. The liquidator is appointed. Within 14 days, the liquidator must notify the Corporate Affairs Commission and publish notice of his appointment. If winding up takes more than 1 year, the liquidator convenes meetings of both members and creditors and presents accounts. The liquidator convenes a final dissolution meeting, advertising it in the Gazette and 2 members and 2 newspapers in the locality. At this meeting, the liquidator lays the accounts of the liquidation before both members and creditors. The liquidator then files the accounts and returns with the Corporate Affairs Commission. He delivers the original certificate of registration or a certified copy for cancellation, and files updated annual returns and other required filings along with evidence of fee payments. Section 635 to 637 of the Companies and Allied Matters Acts apply here. After 3 months of registration, the company is deemed dissolved unless a court orders otherwise. Note: if separate persons are nominated as liquidators at the meetings, the creditor's nominee takes precedence. However, the company, a director, or a member may apply to courts within 5 days to have the company's nominee appointed instead. If creditors fail to nominate anyone, then the company's nominee stands. The effects of voluntary winding up are these. The law ceases to carry on business except as required for beneficial winding up under sections 623. The corporate status continues until dissolution. 3. Transfers of shares without the liquidator's approval are void. 4. Any alteration in the status of members after commencement is void. 5. Once a liquidator is appointed, directors' powers cease except where permitted by the liquidator or by members in general meeting. In creditors' voluntary winding up, the directors' powers cease unless the creditors or their committee of inspection authorize otherwise. 7. Employees are discharged if the winding up is due to insolvency, as in compulsory winding up. When a company is dissolved, in compulsory winding up, the company is dissolved at the time of the dissolution order or at the time stated in the order under Section 617 of the Companies and Allied Matters Act 2020. In voluntary winding up, dissolution occurs 3 months after the liquidator returns the accounts 3 months after the liquidator registers the accounts and returns with the Corporate Affairs Commission. Winding up, subject to supervision of the courts. Finally, there's winding up subject to the supervision of the courts. Where a company has resolved to wind up voluntarily, the courts may, on petition, order that the winding up should continue, but subject to the court's supervision. This is provided in sections 647 and 649 of the Companies and Allied Matters Act. Such a petition operates as a petition for compulsory winding up. Section 650, 651, and 652, subsection 2 make this clear. We now come to the final aspect of winding up. Winding up subjects to the supervision of the courts, the effects of winding up proceedings, dissolution, the roles of major officers, order of payments, and striking off. Winding up subject to the supervision of the courts. Where an order is made for winding up subject to supervision of the courts, Section 652 of the Companies and Allied Matters Act applies. Under subsection 1, the courts may, by the same order or by subsequent order, appoint an additional liquidator. Under subsection 3, the court may remove any liquidator appointed by it or continued under the supervision order, and it may fill any vacancy caused by removal, death, or resignation. A liquidator appointed by the court under supervision stands in the same position as if he had been duly appointed in a voluntary winding up. This is section 652, subsection 2 of the Companies and Allied Matters Act 2020. Now, under such supervision, the liquidator may, subject to restrictions imposed by the courts, exercise all his powers without the intervention of the courts, just as though it was a voluntary winding up. However, there are exceptions. He cannot exercise certain powers under Section 588, Sub 1, paragraphs D, E, and F, namely, the power to pay all creditors in full, the power to make compromises or arrangements with creditors, and the power to compromise debts and liabilities, unless he has the sanction of the courts or of creditors or their committee of inspection, where the winding up began as a creditor's voluntary winding up. Note that the supervision order does not change the commencement date. The winding up is still deemed to have commenced on the date the party passed the resolution. The procedure for winding up, subject to supervision, is straightforward. First, pass a resolution for voluntary winding up. Second, file a petition supported by a verifying affidavit requesting the courts to wind up the company subject to its supervision. Effect of a supervision order, Section 653 of the Companies and Allied Matters Act 2020. An order for winding up subject to supervision has these effects. The liquidator is free to exercise all his powers without court intervention, except for the restricted ones mentioned earlier. He cannot pay all classes of creditors in full, compromise with creditors, or settle liabilities without sanction. Such winding up is treated as compulsory winding up for all purposes, except matters listed in the 12th Schedule to the Companies and Allied Matters Act 2020. Where supervision is ordered during a creditor's voluntary winding up, it will be regarded as compulsory winding up by the courts. Commencement of winding up proceedings. Commencement depends on the type. If there was a member's special resolution, winding up commences at the time of the resolution. If it is by petition, then it commences at the time the petition is filed. This was confirmed in Mercantile Bank of Nigeria against Onwa-Abude. Effect of commencement. From commencement, the following effects apply. No disposition of company property, including choses in action, is valid. 2. Any transfer of shares or alteration of member status is void unless the court otherwise orders. Section 576. 3. No attachment of company property is allowed. 4. No judgment debt can be enforced. 5. The company can no longer carry on business. 6. Its properties cannot be disposed of, nor can its shares be transferred, unless sanctioned by the courts. Sections 411 to 414 are relevant here. Effect on legal personality. Now, does winding up itself kill a company? The answer is no. The appointment of a liquidator or the mere fact of winding up does not extinguish corporate personality. A company under winding up is not dead. It is still alive or sick. A company only dies upon dissolution. This was confirmed in CS Nigeria PLC against Mbakwe. Effect of a winding up order. A winding up order has specific consequences. 1. Actions against the company can only contribute with leave of courts. 2. Employees are automatically laid off. 3. Any disposition of property or transfer of shares after commencement is void. 4. Directors lose their powers to manage the company. Note: under sections 417 of the Companies and Allied Matters Act, once a winding up order is made or a provisional liquidator is appointed, no proceedings can commence or continue against the company without leave of court. However, this does not prevent the company itself from suing others. This is clarified in Onwucheka against NDIC. Dissolution of a company. The procedure for dissolution is simple. 1. First, the winding up must have been completed. 2. The liquidator applies to the court for a dissolution order. 3. Once granted, notice of the order must be given to the CAC within 14 days. 4. The Corporate Affairs Commission records the dissolution in its register. Note: an interested party may apply to the court to defer the date of dissolution. Even after a company is deemed dissolved, the court may void the dissolution on application. The effect of dissolution is final. The company loses its legal entity, ceases to exist, and dies in law. See CBCL Nigeria Limited against Okoli. The name can no longer be used. It is also important to distinguish between liquidation and dissolution. During liquidation, the company is still a legal entity. It can sue it in its name, though it cannot become a member of another company. But once dissolution occurs, The corporate personality is gone. Major officers are winding up. The main officers are 1. The liquidator. 2. The official receiver. 3. The provisional liquidator. 4. The receiver or receiver manager. 5. The special manager. 6. The committee of inspection, whose powers are outlined in section 597 of the Companies and Allied Matters Act. The liquidator. A liquidator is a person appointed by the company or the courts to wind up affairs and distribute assets among creditors, who may appoint either the courts or the company itself. The liquidator represents the creditor's interests, especially unsecured creditors. Upon his appointment, all directors' powers cease. By law, the liquidator must, within 14 days of appointment, publish notice of his appointment in the Gazette and in 2 daily newspapers, and also deliver notice to the CAC for registration. The effect of registration is that the director's powers cease under Section 565, subsection 9 of the Companies and Allied Matters Act. Section 509, subsection 1 of the Companies and Allied Matters Act 2020 lists persons disqualified from becoming a liquidator, and they are: 1. An infant. 2. A person of unsound mind. 3. A body corporate. 4. An undischarged bankrupt. 5. A director of the company being liquidated, or anyone convicted of fraud, dishonesty, corruption, or moral turpitude. Any appointment made in contravention is void under Section 509, subsection 2 of the Companies and Allied Matters Act. Powers of a liquidator appointed by courts. Section 588. Bring or defend actions in the company's name. Carry on business where necessary. Appoint legal practitioners or professionals. Pay creditors in full. Make compromises or arrangements. Compromise on calls and liabilities. Sell property. Execute contracts. Appoint agents and prove claims in bankruptcy or insolvency. Powers of a liquidator appointed by the company. See Section 644 of the Companies and Allied Matters Act 2020. 1. All of the above powers. 2. Additionally, he may make calls, summon general meetings, pay debts, and adjust rights of contributories. The official receiver. The official receiver is essentially the Deputy Chief Registrar of the Federal High Court or any officer designated by the Chief Judge. His role is to receive the company's statement of affairs and report to the court after a winding up order. See Sections 583 and 584 of the Companies and Allied Matters Act. The provisional liquidator. A provisional liquidator is appointed by the courts before a winding up order is made, and therefore the formal appointment of a liquidator. He preserves assets pending the proceedings, especially where there is risk of waste or dissipation. An official receiver often acts as a provisional liquidator. In compulsory winding up, his role ends once a liquidator is appointed. Gen and Aviation Service Industry against Thahal, the receiver and the receiver manager. A receiver is appointed by secured creditors under a debenture instrument. He does not manage the company but oversees income and expenditure to realize assets and pay creditors. He cannot carry on business. A receiver manager, on the other hand, takes over management. He stabilizes the company, tries to make profits, pays off credits, and then hands it back to members. The special manager. This is an officer appointed by the chief judge to assist the official receiver. The special manager This is an officer appointed by the chief judge to assist the official receiver. He exercises the powers of a receiver manager. Powers of a receiver or manager. These include carrying on business, using the company's seal, appointing professionals, selling and disposing of property, establishing subsidiaries, raising or borrowing money, and granting security over company property. Receivership against liquidation. It is important to distinguish between receivership and liquidation. A company in receivership has appointed a receiver to manage debts. It may still recover as a going concern. A company in liquidation, however, is already in the process of winding up. Order of payments. Section 657 of Comma describes the order in which payment liabilities are paid. 1. Costs and liquidators' remuneration. 2. Local rates and charges due within 12 months before the order. 3. Taxes, including pay-as-you-earn deductions, land taxes, property or income taxes within 1 year. 4. Salaries of junior staff and provident fund deductions. 5. Secured creditors with fixed or floating charges are paid first, then unsecured debentures. 6. Preferential shareholders. 7. Finally, any balance is distributed among ordinary shareholders. Striking off the name of the company in Section 692 of the Companies and Allied Matters Act. The CAC may strike a company's name off the register, either voluntarily or compulsorily. Voluntary application. The company must pass a special resolution, apply to the Corporate Affairs Commission for striking off. 3. Advertise in 3 national newspapers within 28 days. 4. The Corporate Affairs Commission must be satisfied that the reasons are sufficient, that the company has not commenced business and has no obligations, and that is no objection was received during 28 days. Note: an aggrieved person may apply to court within 2 years for restoration. Compulsory striking off. If the CAC believes the company has not carried on business or has failed to comply with CAMA for 10 years, it may institute striking off. Notice is prohibited. Notice is published in 3 newspapers. If no response is received within 90 days, the name is struck off. Again, an aggrieved person may apply to court within 10 years for restoration. Finally, under Section 692 sub 5, even if struck off, liabilities remain as though the company were not struck off. The court's power to wind up is unaffected. 2. Statutes. Today, our focus is on winding up and dissolution of companies. Let's begin with the relevant laws. The key legislations governing this area are the Companies and Allied Matters Act of 2020, the Winding Up Rules of 2001, the Federal High Court Act and Civil Procedure Rules, and the Investments and Securities Act. We also have the Securities and Exchange Commission Consolidated Rules of 2013, the Banks and Other Financial Institutions Act, the Nigerian Communication Commission Act, and finally, the Companies Proceedings Rules of 1992. And remember, this list is not exhaustive. There are other supporting regulations that may come into play. Now, let's turn to the regulatory agencies. Two agencies are central here. First, the Corporate Affairs Commission, or CAC. The CAC can present a petition for winding up. It is also the custodian of company winding up process. It is also the custodian of company records. And even during the winding up process, companies are still required to file returns with the CAC. The second key body is the Federal High Court, which is the court with jurisdiction to entertain winding up petitions. Moving on, how can a company's corporate personality be terminated under CAMA? There are essentially two ways. One, through winding up, and two, by striking off the company's name from the register of companies if it has become defunct. This latter option is covered under Section 692 of CAMA. Now, let's unpack the meaning of winding up itself. Winding up is the process by which a company is liquidated and dissolved, with its assets distributed according to the rules of priority. This ensures that creditors, members, and even employees receive what the law entitles them to. Importantly, there can be no dissolution without first undergoing winding up. Dissolution comes at the very end, but winding up is what facilitates the distribution of assets. A famous case illustrates the gravity of this process. In Tate Industries plc against Defcom BM Limited, 2004, it was said that a winding up proceeding is a signing of the death warrant of a company or a pronouncement of the death of the company. It is a very serious matter. End quote. And indeed, that statement best captures how weighty winding up truly is. Now, there are different modes of winding up, which is particularly important for the bar part 2. Winding up may be done in one of three ways. First, compulsory winding up by the court. Second, voluntary winding up. And third, winding up subject to the supervision of the courts. Focusing on voluntary winding up for a moment, this itself can take two forms. It may be carried out by the members or by the creditors, and timing is important. If a company passes a resolution for voluntary winding up before any petition is presented, then the winding up is deemed to have commenced at the time the resolution passed. If a company passes a resolution for voluntary winding up before any petition is presented, then the winding up is deemed to have commenced at the time the resolution was passed. That is section 578 of Kama, subsection 1. But if there is no resolution, or if any other situation, then it is deemed to have commenced at the time the petition for winding up was actually presented. That is section 578, subsection 2. Let's talk now about contributories. Contributories are bound to contribute to the assets of the company once winding up has commenced. Who qualifies as a contributory? 2 categories of people. First, present and past members. That is provided under sections 525 and 117 of Kama. And second, any person liable to contribute to the assets of the company, such as someone who had been a member at any time between the 12 months prior to the commencement of the winding up. That is covered by section 556. Now, let us focus on compulsory winding up by the courts. Under section 571 of Kama, the courts may order that a company be wound up, but only upon a petition being presented to it. The court cannot act on its own. It must be formally invited through a petition. So who is eligible to bring such a petition? This is a crucial bar part 2 focus area. 8 categories of people may petition. 1. The company itself or one of its directors. 2. A creditor, and this includes contingent or prospective creditors. 3. An official receiver. 4. A contributory. 5. A trustee in bankruptcy or the person representative of a creditor or contributory. 6. The company's affairs commission under sections 323 of the Companies and Allied Matters Act. 7. A receiver, but only if authorized by the instrument under which he or she was appointed. And finally, a petition may be brought by any or all of these parties acting together or separately. I'll repeat. 8 categories of people may petition. Number 1, the company itself or one of its directors. 2, a creditor, and this includes contingent or prospective creditors. 3, the official receiver. 4, a contributory. 5, a trustee in bankruptcy or the personal representative of a creditor or contributory. 6, the CAC under section 323 of Kama. 7, a receiver, but only if authorized by the instrument under which he or she was appointed. And finally, a petition may be brought by any or all of these parties acting together or separately. Now, let's examine the eligibility of certain persons more closely, starting with contributories. A contributory is not automatically entitled to present a petition for winding up.